Hello, my name is Pamela Zetterberg. I'm an attorney with Russ Law, LLC in Allentown, Pennsylvania. We specialize in business law, land use law, estate planning, and estate administration. My primary area of practice is estate planning. So a question I get asked often is, what happens if I pass away without a will? There are many implications, costs, stressors, all come into play if you pass away without a will. But today in this short video, I just want to address what happens to a single person's personal property if they pass away without a will. I'll speak to what happens to a married person's in a separate video. If a person passes away and they have not had their will done, what happens to their property is governed by the rules of intestate succession. Intestate means without a will, and the rules, they vary from state to state. I practice in Pennsylvania and New Jersey, and it just so happens in those jurisdictions the rules for single people are the same. And the first one is if a single person passes away and they have children. In that case, all of their personal property and assets will go to their children. If the children are still minors, they have to wait till age 18 to receive their inheritance. And just as a side note, whether you're single or married, please get your will done for the sake of your children if you have minor children. It protects them from uncertainty if both parents were to pass away. It avoids potential litigation if different relatives come in and contest who should be the guardian. And then a court would have to decide who's going to raise your children. So for no other reason than that, please have your will done. Another scenario is where a single person passes away and they do not have children and their parents are still living. Then the parents would receive all of that person's estate. Maybe that's what they would want, but in my experience, it's not as likely. Of course, it's not always the case, but typically our parents, they're older, they're more settled, they're in a better financial situation. So if a person was going to do their will, they might leave their assets to their siblings, other relatives, or friends. A third situation is where a single person passes away, they do not have children, the parents are no longer alive, and they do have siblings. In that case, the estate will go to the sibling, or if there's more than one, to equal shares among the siblings. Again, maybe that's what the person would want, but depending on the relationship with the siblings, it could be exactly what they would not want. So it's always important to have your will done. Now, for anyone who's in a long-term relationship, if they're cohabitating, there are no rights to inheritance in Pennsylvania or New Jersey because common law marriage is no longer recognized. There could be a possible exception in Pennsylvania if there's a relationship that predates 2005, but it's by no means certain. So if you are in one of these relationships, the only way to provide for your partner is with a will executed, notarized, and witnessed. So I think it's clear if you pass away without a will, you can see the state determines what happens to all of your property. We work hard for what we have, whether it's a lot or a small amount or a large amount, and for a relatively small fee, you can have your will done, provide for your loved ones, and ensure that your property goes where you want it to go. Please contact us at Russ Law if you have any questions or you'd like a free consultation. It will be our privilege to serve you with your estate planning needs. Thank you.